Welcome, everybody. Welcome to Big Tent. My name is Melissa Kane. I'm the vice chair of Big Tent, and I'm very thankful to be able to be here today to welcome our good friends, Michael Waldman and Kimberly Atkins store back into the tent. As we are waiting and receiving rapid fire, one SCOTUS monumental decision after another, and they are here for a super timely and urgent exploration and analysis of the impact of the court's most significant decisions this year, the effects that they're going to have on American law and the everyday lives of American people, and with all of these decisions in mind, what we can be doing to ensure fair immigration policy, representation, and a free and fair 2026 election. Big Tent USA is steadfast in our commitment to defending our democratic values, our Constitution, and the rule of law. Our goal is to empower our community with facts and calls to action so that we can all become stronger, more effective advocates for our country. We always have impactful calls to action on our website, and we'll add them to the link in the chat. We'll add a link to them in the chat. But before we get started, I do want to highlight a couple. We've started up our letter writing campaign collabs again with Vote Writers and Vote Forward. We need all the help we can get to get people to the polls. Details on how to request letters are on the website, and a link is being dropped in the chat. So please start sending those letters. And also, in honor of the country's 250th birthday this week, Big Tent is putting together a list of recommended reading. It's going to go out in our newsletter this Wednesday. And we've got books from common sense to caste that reflect what it means to be an American and what it took to become America. So if you have books you think should be on the list, feel free to let us know. Again, they're being sent out on Wednesday. Also, as always, we have a lot of amazing programming coming up. Among others, we've got Mary Trump and Jessica Yellen on July 9th. And then we've got Sarah Longwell later in the month, and then Mary Peltola and Bill Hill. So stay tuned and look for invitations forthcoming. All right, we're ready to get started. Michael Waldman is president and CEO of the Brennan Center for Justice at NYU Law School. Hi, Michael. A nonpartisan law and policy institute that works to improve systems of democracy and justice so they work for all. The Brennan Center is a leading national voice on voting rights, money in politics, criminal justice reform, and constitutional law. Michael is a constitutional lawyer and a writer who is an expert on the presidency and American democracy. He has led the center since 2005, and he was a member of the Presidential Commission on the Supreme Court of the United States in 2021. 2021. And there is no better person to lead a discussion with Michael on SCOTUS than our good friend, Kimberly Atkins Store. Hi, Kimberly. Kimberly is a senior opinion writer and columnist at the Boston Globe. She's also an MSNBC contributor, a frequent panelist on NBC's Meet the Press, and she is a co-host of the Sisters-in-Law podcast. And previously, Kim was the inaugural columnist for The Emancipator, a nonprofit digital magazine collaboration between the Boston Globe and Boston University's Center for Anti-Racist Research. Welcome, Michael and Kimberly. There couldn't be a more timely time to have you here. I mean, today, with things coming out rapid fire, good and bad. Kimberly, before we went live, we were talking about how basically what's happening now at the court is a coronation of Trump. And I want to let you guys get to the discussion that I know you want to have about what do you do with this and what's next. So thank you guys for being here.
Thank you, Melissa, for the generous introduction. And hello to Michael. It is nice to see you again.
Same here.
We have a lot to discuss, and we only have an hour, plus we want to leave plenty of time for questions from our audience. So I'm just going to jump in, to give everyone an overview. We're going to talk about this Supreme Court's term, but also step back a little bit more to see what this Supreme Court has meant in this moment as we celebrate our nation's 250th anniversary, what it's meant to the presidency. And speaking of the presidency, I think that is a good place to start. Michael, I sort of group the cases this term in a bunch of buckets, and one big bucket deals with presidential power. And just this morning, we got two decisions on that. I would say in a way, it's one big decision with one small carve out. Is the way I would think about it. We had the ruling that the president is allowed to fire anyone he wishes in most executive agencies within the executive branch. It's really a stark expansion of the unitary executive. But they gave one little carve out, and that is the Federal Reserve Board, which, for reasons they lay out, but I'm not sure I'm clear on, is different than other federal agencies. So, talk a little bit about your reaction to saying that the president, currently President Donald Trump, has the ability basically to craft every federal agency in the government but one into his own image, a decision that threw out a 90-plus-year-old precedent.
You're exactly right. It threw out a 90-plus-year-old precedent. First of all, I should say it's great to see you again and be with all of you. And thanks to the folks at Big Tent. It not only this ruling today, the Slaughter case,
Mhm.
not only tossed out a precedent from the 1930s uh, that had said that presidents cannot fire the commissioners on independent agencies if Congress had passed a law indicating that presidents couldn't do that. It really affects agencies that were created by law by Congress going back to the 1880s. A lot of how American government does its business is through these expert agencies that sometimes there is a requirement that there be mixed Democrats and Republicans on their boards. Sometimes there's just long terms. They want independence. They want expertise. They that is how modern government was created by Congress. And what this decision does is six justices said, no, we don't like that. And they threw it all out in the sense that presidents can fire these commissioners. Now, they left unanswered some of the broader, bigger questions of can presidents, what else can presidents do with these independent agencies? Um, but the power to hire and fire is pretty significant, and to punish friends and to reward friends and punish enemies. So it's a pretty big power grab by the court by giving even more power to the president.
Yeah, what one thing that I found really remarkable, Michael, aside from just brushing away this precedent called Humphrey's Executor, which goes back to uh, FDR's attempt to fire someone from the Federal Trade Commission because that person would have been a problem for his New Deal policies. And the Supreme Court then unanimously said, no, Congress created this to be independent for this reason. It's not meant to bend to political whims. They dismissed that, but one thing that Chief Justice John Roberts focused on in his opinion is the idea that a president needs to have people in his executive branch that he can trust. To me, that sounded like giving constitutional protection for a loyalty test. Is that what it seemed like to you?
You know, it's pretty alarming in that way. And they embraced here, as you said, uh, a version of what's called the unitary executive theory. And this is the idea that, as they said here, and as they have said in other cases, including the immunity case, that the executive branch really is an extension of one person, of the president. And that all goes back to a word choice in the Constitution where it says the executive power is vested in the president of the United States. If they just hadn't used the word the, uh, they would have they would maybe point to something else, but they wouldn't be pointing to that
Right.
word the. And taken to its extreme, the idea is that everyone in the whole executive branch works directly for the president as though they were a gardener at Mar-a-Lago.
Yeah.
And taken to its extreme, that would mean laws passed by Congress and signed into law and statute books by other presidents governing things like civil service protections or other things of that nature, those are also affected. Now, again, they didn't rule on all of that stuff. They really ruled on a very specific thing, which is can a president fire commissioners in these independent agencies without a cause. And but the implications from John Roberts of this, are pretty stark. So, who knows what they will do? This is on its own a very big deal. I'll note, Kimberly, as you no doubt know, presidents of both parties have chafed under this rule
Yes.
for a long time,
Yeah.
starting with Franklin Roosevelt himself, who was trying
Right.
to fire a really reactionary Federal Trade Commissioner who sort
Mhm.
of barricaded himself into his job. Um, and so, one of the implications of this surge of power to presidents is it won't just be Donald Trump, but whoever comes after him who will have this kind of power.
Yeah, I mean, to quote Brett Kavanaugh, right? What goes around comes around. So that is definitely true. So there was also the case of Lisa Cook, in which the court, in a very, very limited decision, uh, declined the government's bid to force her out of the Federal Reserve while even before her challenge to her firing has finished going through the legal process. They emphasize that it was a very limited opinion, another opinion by Justice John Roberts, but in a concurrence, Justice Kavanaugh tried to make it very clear that he thinks that the Fed is different from what they decided in Slaughter. What did you make of that ruling? And is it much of a silver lining here?
Well, a little bit of a silver lining, maybe, but it really reveals the flimsiness of so much of the way this court is operating. They had signaled this earlier in what's called a shadow docket ruling,
Yes.
where they, in the course of allowing the firing of another commissioner in another agency to go forward, everybody had said, well, wait a minute, if you do that, then that will apply to the Federal Reserve too, wouldn't it? And wouldn't that really be like bad for the economy and all the kinds of economic views that you as conservative Republicans hold dear? So in this earlier shadow docket decision about a year ago, they said, well, then there's the Federal Reserve. It's just different. It just is. And why Alexander Hamilton, he had a bank. That was about the entirety of its historical analysis. This blows it out, extends it out a little bit, talks about the tradition of central banking being independent and separate from the executive branch and other things of that nature. But and it does raise possibilities that there may be other agencies where there's a real structural reason why you might want to have a separation from politics. Um, it should also be protected in a separate way. But it is worth noting that what this decision read one way says is it didn't really purport to rule on whether the Fed has some constitutional difference, but just that they had not made the showing that Lisa Cook, because they didn't make any showing really that Lisa Cook had done anything wrong. But
Yeah.
in order to do that, they had to acknowledge that Congress could pass laws determining what is the basis for hiring and firing a governor of the Federal Reserve. And so, in that sense, they did make a constitutional ruling, even though they didn't really hang a big sign around it.
Yeah.
Um, you know, what's the consistency? There's not a ton of consistency there, except that you could, again, as I said, you could make an argument. Well, there might be some structural reason why this agency you really want it separate and away from the political process. There are other agencies like that too, but it's also hard to escape the observation that when you look at some of the big presidential power cases of this term, the tariffs, where we were
Hmm.
strongly supportive of the position the Supreme Court took, blocking Trump's unilateral uh,
Yep.
attempt to impose tariffs, and the FTC case and the Fed, the through line is, big business didn't like the tariffs, doesn't like the FTC, and does like the Fed.
Yeah.
And so, there's a kind of at least an ideological, if not jurisprudential, consistency here.
So there's one more presidential power case that I wanted to talk about, and that's the one challenging Trump's executive order purporting to limit birthright citizenship to those essentially that Trump likes, and not to everyone. That decision will come down tomorrow. We know that tomorrow is the last day of opinions this term, and it still hasn't come down, which means it's coming tomorrow. How are you feeling about that case, and what do you think the court might do?
You know, that case should be an easy, open and shut case. It is literally in the wording of the Constitution that if you're born in the United States, you are a citizen. That is quite literally the purpose of the 14th Amendment was to overturn the Dred Scott ruling, the egregious racist ruling, which said otherwise. And it's right there in plain language. And so I would hope that the court would rule that way. And if they do, and when they do, I'll be happy. But I don't think they deserve that much credit because this really should have been a very easy case. Um, the fact that it's taking till the last day uh, uh, suggests that there may be some contention on the court, which would be mind blowing. This is
Yeah.
something that President Trump purported, as you said, to do in his first day in an executive order. And you cannot sharpie out the language of the Constitution. It's just plain as can be. So I would certainly be very shocked if the court ruled to uphold Trump's executive order. But they're making things more nerve wracking than they need to be.
Yeah, I share your view. I think that this is a pretty clear-cut case. I'm imagining that it's at least 7-2 against this executive order. A couple things about why it's taking so long. It was one of the last cases that was argued this term, and there's been a lot of other cases, so it could just be a bottleneck issue. Um, Somebody, perhaps Alito or Thomas, is might be writing a fiery dissent that takes time to circulate. I don't know, but I don't make predictions very often. I predict the Chief Justice will write that one. It seems that big constitutional issues that have some political bite to them, he likes to save for himself. And I can't imagine him ruling for Trump on this issue. Um,
That seems right.
others others as well. Just a couple more, again, about executive power that we got last week, a couple of immigration cases, one that upheld President Trump's ability to summarily end TPS protections, even when the government itself, there is evidence that the government didn't follow its own rules. While on the other hand, TPS holders, these are people who are temporarily protected to stay in the United States because their home countries are just too dangerous or unstable for them to return to. They said that he could do that. They also blessed the practice by this administration to physically stop people from the border before they can apply, cross the border and then apply for asylum. Again, legally, people can apply for asylum when they present in the United States or if they're already here. The court said, well, if the government is making immigration agents keep them from getting to the border, then no, they don't have the right to apply to asylum. What do these immigration cases say about how the court is viewing executive power?
Well, at one level, you're certainly right that they are part of this pattern of this court, generally speaking, giving this president more and more power. And I say this president because of course, in many ways, these powers don't just go to this president, but to other presidents in the
Right.
future. But this president is certainly pushing the boundaries and using the power that he has and going far beyond that and doing things illegally, even when there are legal ways to do things um, over and over again. One of the things that's noteworthy about how the Supreme Court seems to be treating Donald Trump this term of his presidency as opposed to his first term. In his first term, there were times when, in immigration cases, for example, where the court would stand up to him. But it was very often around, well, you didn't quite do it right. You didn't cross your T's and dot your I's. You didn't follow the Administrative Procedures Act or some other um, technical body of law that, excuse me, that is how you're supposed to make decisions in government. This time, starting with the immunity case, even before Trump took office, they're just giving him what he wants.
Yeah.
And, you have to wonder, is that because now there's a 6-3 supermajority of very conservative, very doctrinaire justices? and that just changes the dynamic on the court. Is it because, frankly, because Trump actually won this last election in both the popular vote and the electoral college, whereas that had not been the case in 2016? He won the electoral college, of course, but lost the popular vote fairly decisively. Who knows? But they are treating him very differently this term than they did in the first term. And that, of course, continues to be grounds for concern.
So I want to talk about voting and election rulings this term, coming up to the midterms. The biggest, what I believe is the most consequential decision of the term, is the erosion to almost nothing of the
Right.
Voting Rights Act. We had the Calais decision, and I think even more damaging on top of that were the subsequent shadow docket rulings in different states, which seemed to expand Calais even farther than it went. It basically nullified the ability of people to bring suit under the Voting Rights Act to try to stop racially discriminatory gerrymanders. And the court essentially struck down that ability. Michael, what does that mean in terms of democracy?
I think you're exactly right. I think these are the cases that this court is going to be remembered by more than anything else in this term. The Calais case, as Justice Elena Kagan put it, leaves the Voting Rights Act all but a dead letter.
Yeah.
The Voting Rights Act, of course, was in many respects the most effective civil rights statute. It transformed American life and politics. It led really to the creation of the opportunity for a multiracial democracy for the first time in our country's history. And it has been the subject of a campaign over several years led by John Roberts to destroy the Voting Rights Act. Despite the fact that it was working, and despite, again, for all their pretenses that they're just, leaving all the major questions to Congress, the
Yeah.
last time the Voting Rights Act was reauthorized, which was not that long ago, it was in 2006, it
Mhm.
passed the Senate 98 to nothing. This was a bipartisan consensus that this was good for the country, but the Supreme Court has taken a sledgehammer to it, and there's not much left. What does this mean? What we are seeing in the short run, very alarmingly, is a rapid change in drawing of district lines, especially in the South. And with the help of these additional Supreme Court shadow docket rulings, letting these states do their stuff now in a way that affects this election and making it very hard to ever prove racial discrimination in voting. And it will likely lead to a rollback in representation in legislatures and in Congress of uh, of communities by members of Congress who are Black and Latino, a rapid rollback that we have not seen since the end of Reconstruction.
Yes.
Um, it's not entirely clear what the partisan implications are going to be, uh, because we don't know how all these district lines are going to play out in different election years, and we have not seen the full implications of this because a bunch of states held off, including, for example, South Carolina
Yeah.
and Georgia, where citizen protest by the affected communities actually caused them to back off trying to do it for this election. But there's no doubt that this is going to have an impact, not just now, but in 2028 and going forward. And you'll also see northern states redrawing their districts. So I think it's a very alarming uh, shift in representation, and we all need to be yelling about it. We need to be talking about it. We need to be, I would say, voting about it, and we need to be demanding that Congress act if they have power, when they have a chance, to do something about it.
Yeah, and I also think here in on your point about voting about it, elections still are, despite what the president wants to believe, and we'll get to another opinion on that soon, they are still run by the states. And so the vote that you cast for your state officials, your election officials, your secretaries of state or equivalent, your governors, your state lawmakers are crucially important because the same sort of pressure you talked about from people in North Carolina and Georgia who or South Carolina and Georgia who put off this decision until the next election about how they'll redistrict. That's important. They're listening to their constituents. And to the extent that they are doing that, that just shows the power of the electorate in this. So I get asked a lot, what can we do? That's one thing. Voting really does matter in a really, really appreciable way. But on the Calais decision, one thing that I think, regardless of what you think of the outcome of that case, the court really gave itself a black eye because of how inconsistent it was with its own reasoning. Calais purported to hold that you cannot bring a challenge under the Voting Rights Act against racial gerrymanders that are not intentional, that are just de facto. And
By the impact that they
that
have. You
impact,
have to
disparate
prove that there
impact.
was
Thank you. I
intent.
was trying to look for that. You saw me
Yeah.
looking for that phrase. It's been a busy week, Michael. You cannot bring racially discriminatory impact claims, but they weren't, touching intentional racial discrimination. Then they turned around right after that, and in a decision in Alabama, even though they had themselves just 3 years ago ruled that Alabama intentionally racially gerrymandered its maps, they turned around and allowed that racially intentionally gerrymandered map to go into effect, citing Calais. So to me, that says, oh, wait, Calais does apply to intentional racial gerrymander. It basically applies to any gerrymandering. And how are we supposed to, and states supposed to, follow this rule if the Supreme Court keeps changing it on the shadow docket? I thought
Well,
that was the most incredible thing.
the other thing, and we've got colleagues here at the Brennan Center, Dr. Kareem Creighton, who leads our Washington D.C. office. He's a political scientist and a lawyer, and he actually was working in Alabama, where he's from, in the legislature at the time of these first gerrymandered maps a few years ago. It's really egregious. And you're correct that the Supreme Court specifically had already struck these down a few years ago
Yeah.
in the Milligan case. Um, the other thing that the Supreme Court did that was just, I think, intellectually indefensible is they said, well, you need to prove intentional discrimination. And if there's some other reason why this gerrymandered map was drawn, that's proof that that's okay. In other words,
Mm.
you can just say, well, it was this other reason was the reason.
It
And
was
in
a political
particular,
gerrymander, for
yeah, and in
example, which
particular,
is fine.
for years, the Supreme Court had said partisan gerrymandering is really bad for democracy. It
Yeah.
leads to polarization. It leads to bad representation. We're going to try to figure out something to do about it. And
Yeah.
they said, well, we can't really figure out what to do. In a case called Rucho in 2019, they said that the federal courts, they and other federal courts, were not going to police partisan gerrymandering. They ruled it, as they say, non-justiciable. But they said it was a bad thing, but they weren't going to try to police it. In this case, they said, oh, well, in effect, partisan gerrymandering, why, that's the good old American way. That's a charming bit of how we run our elections. So all you need to do, if you have a very racially discriminatory map, and you're the lawyer for some state legislature, you just need to say to them, oh, just say it's just to hurt the other party. That's all you need to do.
Yeah.
And then that count, then you have a valid, constitutionally valid reason for passing a racially discriminatory map, is it's really just to
Yeah.
hurt Democrats.
Yeah, and Michael, you
And
know that in many southern states, a partisan gerrymander, the Venn diagram of a partisan gerrymander
right.
and a racial gerrymander is a circle. We need to have time to get to the many questions that we're getting, but I just want to quickly mention a couple of other election cases. Tomorrow, we will get a case that will decide whether federal political candidates can coordinate campaign spending with parties. That's something that can infuse a tremendous amount of money into the campaign coffers. It matters now because as we stand, the Republican congressional committees have raised far more money than the Democratic ones, so that could make a difference in the midterms. We also today got the decision about mail-in ballots. The Supreme Court said that states that receive mail-in ballots by election day but count them in the days after do not violate federal law. I thought that was a big one, especially since the president has so targeted his ire at mail-in voting.
So on the case today, that's the Watson case.
Yes.
I would say the Supreme Court correctly chose not to do a bad thing. The status quo is goes forward, the several dozen states that count ballots from people who cast their ballots before election day. You can't vote after election day,
Right.
but if you cast your ballot before election day and say you're in the military or overseas or whatever, and states have a grace period where the ballots can come in, that's the way it's been. And the court didn't do the ridiculous step of somehow discovering that a law from 1842 passed by Congress blocked that. So I'm glad they did it, but I my main message to voters out of that is just ignore a lot of the noise. Every time there's even a ruling like this, some people worry, oh, maybe I can't vote. Maybe I'm not going to get my vote counted. People should make a plan to vote. They should prepare to vote. They should vote early if they can, and other ways. And this was one thing. The case tomorrow, to me, it's not, there's going to be maybe a potential and predictable partisan impact, as you described, because of how the campaigns and the party committees are doing right at this moment.
Yeah.
But the bigger thing is this too, we don't know fully what the outcome will be, of course. It's part of a long effort by this Supreme Court, which has demolished congressionally enacted voting rights laws, also to demolish campaign finance rules and laws passed by the democratically elected branches, going back to Citizens United and other cases too. And there's not a whole lot left of the campaign finance laws in the United States. If people like this money drenched system, if people like the polarization that comes from gerrymandering, if they like the rollbacks of voting rights, the Supreme Court really has a lot to do with all of that. And it really, to me, it just reinforces the problem of the role the Supreme Court is playing right now in our system, which it is very active, very energetically interjecting itself in how we run our democracy, and almost invariably in a way to make things worse.
Yeah. So there are a lot more cases on this term than we can discuss in just the allotted time we have. Of course, we have decisions coming up when it comes to banning trans students from playing sports. We've had decisions on the death penalty. We've had a lot of other big rulings, but I want to get to some questions. I'm sure people may ask questions about some of the other rulings this term, but I want to start with a really good question that we received, Michael. Many Americans have lost confidence in the Supreme Court, and some have even questioned its continued legitimacy. What steps, if any, could help restore public trust in the court?
Um, the Supreme Court has vast power and minimal accountability. Um, and it wields that power not because it has an army, not really because the Constitution explicitly gives it that power. The part of the Constitution dealing with the courts is only 1/10 the length of the parts of the Constitution dealing with the democratically elected branches of government. The Supreme Court only has that power because we give it trust, and it has squandered that trust in significant ways, in my view. Public approval of the court is at the lowest level ever recorded now, scraping along. Um, I think that there are a number of things that make a great deal of sense to do to restore public trust in the court to where it needs to be, because we want to have a strong and independent and effective Supreme Court under our system. First and most important, I think there need to be term limits for justices. Um, we support an 18-year term limit. The basic premise is nobody should have too much public power for too long. It's sort of what George Washington taught us when he limited his presidential term, as he did. Um, Term limits can be done by constitutional amendment, but they actually can be done as well by statute, we believe. And if you coupled that with the ability of a president to make a nomination every 2 years, that would do a lot to take a lot of the political craziness out of the confirmation processes and bring the court more in line with the public. And here's the thing that's kind of interesting, which I think people on this call would be maybe surprised by. Term limits are very, very popular. The most recent Fox News poll showed that 78% of the public supports Supreme Court term limits. So that's obviously a lot of Republicans and independents as well as Democrats. There are very few issues that have as much breadth of support. So I think that's the first step. I think there's also a pretty obvious need for a binding ethics code with some enforcement mechanisms. They finally gave in and had a kind of toothless ethics code a few years ago. And they announced when they did it, they said, this is just to clear up a misunderstanding by the public that we have something going wrong. And there are other things too. I think, a number of people are very concerned about the shadow docket, which is the way they're increasingly making decisions without ever fully explaining what they're doing, um, often without signing their names. And there's ways of improving that, and there are other things as well. I do think a lot of the problem comes down not to the Supreme Court, but Congress.
Mm.
Congress has abdicated its responsibility on so many of these things, and when the Congress is supine, you get both executive abuse, but also Supreme Court overreach. And so there are things Congress needs to do as well to respond to these specific cases in a variety of ways.
Well, speaking of congressional power, we got a question about the Voting Rights Act case. Can we count on this court overturning any congressional acts trying to reinstate Section 2? That would be tricky, right, Michael? Because the court didn't, well, technically saying they did not strike down Section 2. The opinion by Justice Alito explicitly stated that any remedy that basically ungerrymanders a map could be seen as an equal protection violation against white voters, right? So that
Right.
ties
And
Congress's hands a bit.
that you need they basically took they exported the rationale used in the higher education affirmative action cases about a quote colorblind constitution and applied it to cases dealing with voting under the 15th Amendment, which explicitly is about protecting people against discrimination based on race
Right.
in voting. It's very hard to have a quote colorblind constitution when you're
So
trying to enforce the
they
15th
forget
Amendment.
Reconstruction a lot, this court.
Yeah,
These are
they're
Reconstruction era
rewrite.
amendments.
They're done with 1776. They're busy rewriting 1868. It is. There are things Congress can do to protect against the worst abuses, even under this misguided doctrine by this court. Congress can, and we've urged them to, first of all, ban partisan gerrymandering nationwide. This would apply in red states and blue states alike. Uh, and given, as you said, how much race and partisanship are bound up together, it really would get at both would be good on its own terms, but would also get at a lot of the issues around racial discrimination in gerrymandering. Congress can and should pass national legislation on the right to vote, giving everybody the ability to sue if their voting rights have been infringed upon. That, believe it or not, is not, there's no current statute that passed by Congress that has that right, because in the past the courts have upheld it, but now they're not. And Congress, as I said, can and should pass uh, uh, Supreme Court reform, and they should pass legislation making it really clear, making it easier to prove intentional discrimination. There's a fairly robust suite of things that we've been urging Congress to do in response to this, and I think that many people in Congress actually understand the significance of this moment. It was really striking, for example, right after the Calais decision, that the Congressional Black Caucus, for the first time, their immediate response was, okay, now we really need term limits. In other words, it was an understanding that playing the same game of going before these justices and acting as though it's on the level, and if we just do the arguments a little better next time, maybe we're going to win. People have come to see that unfortunately is not the case.
Yes. I'm going to turn back to the issue. I think this question is about the slaughter decision. The question is, it seems these rulings really diminish the role of Congress. What is the impact on Article 1? It is true, that Congress is the one who created these agencies, and they are the ones that set the rules for the agencies. Yet, the Supreme Court said those rules violate separation of powers. How do you square that, Michael?
Yeah, I mean, the Supreme Court in other cases has been very sanctimonious about, oh, Congress runs the show, and we just think it's terrible for these agencies to do their thing without Congress saying what they should do. And you saw that in earlier cases, uh, as for example, when they created what's called the major questions doctrine,
Right.
saying that Congress has to decide major questions, even if the laws passed by Congress, this is a few years ago, actually give the legal authority to regulatory agencies to do something. No, Congress has to do it.
Right.
Here they're saying Congress did not have the power to create these
Yes.
rules for the hiring and firing of these commissioners of these agencies. Um, and the only reason they say that is because they happen to have a different view of how things ought to work. It's an ideological ruling. And it, they went back to 1787, and this is the idea of originalism, that the only thing that matters in understanding the Constitution is what the guys in the powdered wigs, back then thought things were supposed to mean, but ignored the way we as a country from the 1880s going forward built our modern United States behemoth of an economy with these independent agencies doing their critical role. I mean, one can envision another way to have structured these agencies, but this is not how the law was written for decades. And now these six people acting very ideologically um, have just said, no, no, we don't like that. You have to do it a different way. Congress, I think, members of Congress from both parties, um, but certainly the Democrats, are going to have to really think very hard about what they can do to reclaim their power here. There are agencies like the GAO, the Government Accountability Office, that is a congressional agency.
Yeah.
There are other ways and the court, I believe in this ruling, I'd have to double check, said this isn't about those kinds of agencies.
Right.
Congress could do more to pass more agencies like that to you know but in all of it, members of Congress are going to have to do something they haven't done in a while, which is shake off their stupor and actually do their jobs.
Yeah. So I know we just talked about partisan gerrymandering, but I want to go to this question because I think it brings up a bit of nuance that's important. The question is, I don't understand why partisan gerrymandering is legal as it diminishes the individual voting rights, just as racial gerrymandering does. So technically, it's just I will start off with 2 points in that, and then I'll throw it to you, Michael. Technically, the Supreme Court did not rule that partisan gerrymandering was legal. What they ruled was it was non-judiciable, which means that courts cannot hear challenges against partisan gerrymandering because that's strictly a political question, and we leave that to the lawmakers. We have no role in looking at that. We can just put blinders on and blind ourselves to whatever the result of partisan gerrymandering is. But what it leaves open is, again, in the states. There are many states that have laws and constitutional amendments in their state constitutions which prohibit partisan gerrymandering. So, again, that gives the power to the people. You have more representative government at the state level than you do at the federal level. We're talking a lot about what Congress can do and doesn't do, but your state lawmakers are the key power holders on this issue. If they act to protect against partisan gerrymandering and say, hey, we're not doing that there, or if they do things like in Michigan, set up an independent commission to do their map drawing, there's lots of things that people that can be done at the state and local levels to protect the elections, how they're administered. Because again, elections are administered by the state with some limited role for Congress in federal elections only. They're really done by the state. So, Michael.
Yeah, so you're right. The key part of the Constitution is called the Elections Clause, and it never really got a ton of attention before recent years. I wrote a 70 page law review article on its history, but I don't know that it was the most widely read thing that my co-author and I ever came up with. The Elections Clause makes clear, and I think it's important for those of us who care about American democracy to see all the elements of it. States set the time, place, and manner, as it's called, of elections, and that includes everything from voting rules to redistricting. Congress, it's important to note, can override the states at any point on these things. That's very clear and very explicit by setting national rules. the president, the executive branch, has no role, and courts keep ruling this way in a bunch of these recent cases, some of which we at the Brennan Center have brought, dealing with Trump's executive orders and other things of that nature. What can states do? You're exactly right that states have considerable power to set rules about redistricting, to create independent, nonpartisan commissions, and that sort of thing. The problem is that some states did that. Michigan, we were very involved in the drafting, actually, in the passage of the ballot initiative in Michigan, um, called with the folks in Michigan. It was very well done, very inspiring, and you have other places as well that have the real protections against gerrymandering, but other states don't have those protections. And what we saw this past year and a half is that starting with Texas, where under pressure from President Trump, in the middle of a decade, Texas redrew its congressional maps to try to squeeze out 5 more seats for the Republicans.
Yeah.
Then California, which had a very strong nonpartisan redistricting commission, they went to the voters to get a new map imposed that would push back on behalf of the Democrats. And you see this arms race going on in the states. So the other piece of this, again, very much pursuant to what the Constitution allows, is Congress can act. And again, if you had something like a national ban on partisan gerrymandering and a ban on mid-decade redistricting, it would apply to red states and blue states alike. Would the Supreme Court uphold this? I mean, are they just playing, is this Charlie Brown with Lucy with the football?
Mhm.
I mean, you never know, but it is noteworthy that in that Rucho case in 2019, John Roberts, writing for the majority, said, "Oh, we're not saying you're right, Kimberly." They didn't say, "Oh, this is great." They just said we can't be the ones to police this, but you know who can? States can, they said, and Congress can. And Roberts and the Supreme Court actually pointed. They said, why, for example, there's a bill now called the Freedom to Vote Act. Why that would be constitutional is really quite an amazing thing, because they don't do that very often. They
No.
don't pre-approve the constitutionality of legislation. This is the bill that was HR 1 that came very close to enactment under
Yeah.
Biden a few years ago. And my view was they never thought in a million years would get close to becoming law.
I think that's
But they
true.
did say it's constitutional for Congress to act and has broad power. So, if they're going to have any consistency at all, they would uphold that kind of thing.
So we have not talked about the gun cases on this docket yet because it's just such a full docket, but we have a question here that will allow us to dive into that a little bit. Has the court ever explained why the intent of the drafters of the U.S. Constitution should control the disposition of cases at the time and ignore the legislative intent of the drafters of U.S. statutes? No place is that more relevant than in the Second Amendment jurisprudence after Bruin. We saw last week the Supreme Court struck down what I thought was a pretty common sense law in Hawaii, saying that you cannot bring a concealed weapon on private property, even in shops and restaurants, unless you have the consent of the owner. Hawaii, of course, has a long history of tradition of not being a gun place, that guns just really aren't a thing there, has the lowest gun fatalities in the country as a result, but they still have to apply it to the standards the founders were thinking of when there were muskets and such. So has the court really explained why that is the new standard?
They've explained it badly and with half the time wrong facts and historical arguments. I wrote a book about the history of the Second Amendment a few years ago, and people would be perhaps surprised to learn or remember that the Supreme Court never said that the Second Amendment protects an individual right to gun ownership for self-protection or whatever until 2008,
Yeah.
the Heller case. That was the first time they did that. I mean,
Yep.
previously they'd said that the Second Amendment addressed gun ownership for serving in a militia, the state
Yep.
National Guard, basically.
That's such an
Um,
important point because I remember being a reporter covering the court at the time and leading up to the opinion. Folks like me were focusing on the comma in the clause and wondering if they, how they were going to square whatever they were going to do with the fact that it was for militia. And they just pulled a whole new rationale out of the sky. Like that didn't
right.
seem
Well, and they
to,
they
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 made it
basically
up.
said, look, uh, the history that they used was really flawed. I mean, if you look at what the framers thought they were doing, uh, when when they cared a lot about those militias, they were not like anything we have today. There was a universal draft for men, eventually for white men, ages 16 to 60. You had to belong to a militia, and you were required by law to own a gun and to bring it in for your militia service. Think of like the Minutemen, in the Revolution. And they, if you recall, the Bill of Rights, including the Second Amendment, was a piece of legislation drafted by Congress. It was written in public. They just like on C-SPAN, there was a debate on the floor of the Congress about the Second Amendment and what it meant. And there were 12 people who spoke. Not one of them talked about it being for self-protection. It was all about whether the Quakers would get, and others, whether there'd be a conscientious objector provision so that Quakers wouldn't have to serve in the militia, which was what the opinion was, which was what the amendment was about. Um, Heller and then these other gun cases said, no, the only appropriate way to look at the Constitution is originalism, is the idea that you have to look at what the framing generation thought it meant, and ignore, in effect, all the history after that. But even then, they said, look, that case was written by Scalia. They said, look, there's still ways to uphold gun laws. A number of these laws are still presumed to be allowed. And Scalia was once asked, what's the difference between you and Justice Thomas? And he said, well, I am an originalist, but I am not a nut. And Thomas was the one who wrote the Bruin decision a few years ago. And that said that literally a gun law today could not be constitutional unless it was basically a gun law they had back in 1787.
Right.
You had in this term, ignoring the fact that Hawaii has centuries of tradition of keeping guns out of businesses, or another case where they were looking at whether or not you could deny somebody a gun because of substance abuse, where they spent a lot of the time in the oral argument debating how much ale, founders drank,
Right.
and where they drunk all the time. And so their concept of, it wasn't really good tap water. So their concept of how much was too much inebriation, that's what ought to control us now.
It was a little
it's
skewed,
an insane way to read the Constitution. There's no other country in the world that does it this way. In England,
It's true. It's true. I hate to cut you off, but
yeah,
we're coming to the end, and I'm going to give you
I have
1
only
minute.
another hour or two on this.
I'm going to give you 1 minute to answer a big question, and that is, what is the consequence if a state decided to ignore a Supreme Court decision?
Well, we don't want states to do that. We had that happen in the run-up to the Dobbs case, where states ignored the Supreme Court's decision in that case in Roe v. Wade. And so I think the better path for people who want to change these decisions is, yes, there are times when you want to we've proposed, for example, trigger laws under Citizens United, so that if the doctrine ever changes, strong campaign finance laws will go into effect in states, challenging the court politically, demanding that people running for office, especially for the Senate, stand up for a vision of the Constitution that is pro-democracy, and much more. I think that is the more productive path. We don't want to devolve into a country where the rule of law is just a suggestion.
I agree with that. And it's worth noting that state attorneys general have played a yeoman's role in challenging a lot of presidential policies. That's a good way for states to respond. They've also brought, by bringing challenges, many of which that go to the Supreme Court, and also by writing friend of the court briefs in important issues. So this was a great discussion, Michael. It is time for me to turn it back over to Melissa.
I wish you didn't have to. We clearly could use another hour or two or three, especially with Trump v. Barbara, I guess, hopefully, that's coming down tomorrow. I have to say, what stuck out to me is the problem with Congress. I mean, Michael, you said it, abdicating power, abdicating responsibility leads to executive abuse and SCOTUS overreach. And then interestingly, this ruling or these rulings that have diminished the role of Congress. So it leads us back to what can we do? Make sure we get the right people in Congress and that we push really hard for Congress to act as they need to. So anyway, thank you as always for being here to help us unpack. It seems like new paradigms being introduced almost daily by these really momentous decisions. And for talking to us about what we can do. I wrote it down. Vote about it. Vote about it. That's what we've got to do. And will you come back, please, please, please? We love having you here.
Always.
Wonderful. And do you have any thoughts for us for our America 250 reading list? If you do, we'd certainly love your advice.
I have a whole shelf of banned books, many of which get to
Yeah,
many of the things that are important for
it's
America.
important that, yeah, there's a ton of good banned books out there.
Yes.
I'll mention three books about the Declaration of Independence itself as
Right.
we get up to this weekend that I always encourage folks to read.
Please.
One is the book American Scripture by Pauline Maier about the writing of the Declaration of Independence and how in that spring of the revolution, towns and villages all over the country were writing their own declarations of independence and sending them into the Continental Congress. And actually, it wasn't just Jefferson's voice, certainly, or even the others, the Virginia resolutions, but it was the voice of a very small d democratic uprising being embodied there. The second book I always encourage people to read is by Danielle Allen, about
Mm,
called Our Declaration, about the particular significance of the Declaration for her family, for the Black freedom struggle, and how people misread some of the punctuation in it, and it actually is all about democracy. And then the final book that I always encourage people to read, and you can actually read an excerpt of this too on the Atlantic website, is Gary Wills's Lincoln at Gettysburg, which talks about how Lincoln, in saying 7 years ago, backdated the beginning of the country to 1776 and the Declaration and its notions of equality and freedom, as opposed to the Constitution, which of course had condoned slavery. It's a tight little book. It's quite brilliant.
All of those books will be on our reading list. I suggested Common Sense, which also was banned. Anyway, thank you both again so much. We love having you in the tent. And thank you to everyone who joined us today. Please mark your calendars for July 9th for Mary Trump and Jessica Yellen. Please follow us on social media and on Substack. Please come back soon. And thank you again to the amazing Michael Waldman and Kimberly Atkins store. We couldn't do it without you. Thank you.
thank you
Thank you.
for
Bye,
having me.
everybody. Have a great afternoon.